Extradition law in the United States is the formal process by which a fugitive found in the United States is surrendered to another country or state for trial, punishment, or rehabilitation. For foreign countries, the extradition process is regulated by treaty and conducted between the federal government of the United States and the government of a foreign country. International extradition is considerably different from interstate or intrastate extradition. If requested by the charging state, U.S. states and territories must extradite anyone charged with a felony, misdemeanor, or even petty offense in another U.S. state or territory, even if the offense is not a crime in the custodial state. The federal government of the United States is a separate jurisdiction from the states with limited scope, but has nationwide law enforcement presence. The extradition clause in the U.S. Constitution requires states, upon demand of another state, to deliver a fugitive from justice who has committed a treason, felony or other crime, to the state from which the fugitive has fled. 18 U.S.C. Section 3182 sets the process by which an executive of a state, district, or territory of the United States must arrest and turn over a fugitive from another state, district, or territory, for a person to be extradited interstate. 18 U.S.C. Section 3182 requires. In Kentucky v. Denison, decided in 1860, the Supreme Court held that, although the governor of the asylum state had a constitutional duty to return a fugitive to the demanding state, the federal courts had no authority to enforce this duty. As a result, for more than 100 years, the governor of one state was deemed to have discretion on whether or not she would comply with another state's request for extradition. In a 1987 case, Puerto Rico v. Brastad, the court overruled Denison, and held that the governor of the asylum state has no discretion in performing his or her duty to extradite, whether that duty arises under the extradition clause of the Constitution or under the Extradition Act, and that a federal court may enforce the governor's duty to return the fugitive to the demanding state. There are only 4 grounds upon which the governor of the asylum state may deny another state's request for extradition. There appears to be at least one additional exception. If the fugitive is under sentence in the asylum state, he need not be extradited until his punishment in the asylum state is completed. As of 2010, in practice, Florida, Alaska, and Hawaii typically do not request extradition if the crime in question is not a felony because of the associated costs of transporting the suspect and the housing fees that must be paid to the jurisdiction in which the accused is held until transported. All states except South Carolina and Missouri have adopted the Uniform Criminal Extradition Act. Intrastate extradition may be necessary if a fugitive is arrested by a local police force in the same state or territory as the offense was allegedly committed. The procedure for doing so depends on state and possibly local laws. The United States has extradition treaties with more than 100 countries. Most of them are dual criminality treaties, with the remaining being list treaties. The United States maintains diplomatic relations but does not have extradition treaties with the following countries. The United States does not have diplomatic relations or extradition treaties with the following countries. The United States does not recognize the following polities as sovereign states and does not have extradition treaties with the following countries. Generally under United States law, extradition may be granted only pursuant to a treaty. Some countries grant extradition without a treaty, but every such country requires an offer of reciprocity when extradition is accorded in the absence of a treaty. Further, the 1996 amendments to 18 U.S.C. 3181 and 3184 permit the United States to extradite, without regard to the existence of a treaty, persons who have committed crimes of violence against nationals of the United States in foreign countries. All extradition treaties in force require foreign requests for extradition to be submitted through diplomatic channels, usually from the country's embassy in Washington to the Department of State. Many treaties also require that requests for provisional arrest be submitted through diplomatic Channels. Although some permit provisional arrest requests to be sent directly to the Department of Justice, the Department of State reviews foreign extradition demands to identify any potential foreign policy problems and to ensure that there is a treaty in force between the United States and the country making the request, that the crime or crimes are extraditable offenses, and that the supporting documents are properly certified in accordance with 18 U.S.C. Section 3190. If the request is in proper order, an attorney in the State Department's Office of the Legal Advisor prepares a